Hello. Thanks very much for coming along to this paper today with Professor Rebecca Parry. I'm John Tribe from the University of Liverpool. I'm just going to introduce briefly Rebecca, and then I'll chair the questions section at the end and talk through some of the online participant questions and any that we have in the room as well. So just a brief introduction to Rebecca. She's now at Nottingham Trent University. Prior to that, she was at Leicester, and then even before that, she was supervised by Professor Millman as well, where we had that link earlier with Belanley and Riz. There's a link with David Millman as well. So Rebecca's doctoral work was on antecedent transactions, and many of you will know that she's then written about that subsequently in 3 editions of that authoritative book, as well as lots of work on rescue generally, with a particular bias towards China as a jurisdiction. So she's well known to us all generally with her corporate scholarship, corporate focus scholarship. And her paper today, I've had the privilege of reading it in advance because of the shortlisting process, is an excellent paper which you'll now hear about, and it's very much in line with this future auspices of the conference. So on that point, I'll pass over to Rebecca. Thanks very much.
Okay, so this paper's looking at how ways of doing things have changed recently. We're in what's regarded as the 4th Industrial Revolution. Ways of working have changed. It's now easy for us to do the same work at home as it is in the office. People can easily follow conferences like this online. And all of this is due to lots of technologies that we take for granted, that we might not understand the complexities of, and where we might not be aware of the risks necessarily of storing things online, of managing projects online, of accessing software online. So the paper's looking at what would happen in the event of one of these companies becoming insolvent. We've had a taster of what the impact of that might be like. Recently, a couple of months ago, there was a company called Fastly that suffered an outage, and people on the internet lost their minds because they couldn't submit official forms. They couldn't use websites that they were reliant on. Companies lost money because of this Fastly. And prior to that, we wouldn't have been aware even of what Fastly was, what the role of that company was in speeding up internet transactions. And it was only out for 1 hour. So what would happen in the event that a company like that entered insolvency proceedings? Now, as I will explain later, there's quite a lot that is being done to control those risks, to have prevention of insolvencies, but thought does still need to be given to what would happen in the event that one of these service suppliers suddenly was facing difficulties that meant that it was no longer viable. That one. So as an overview of what the paper is going to be about, I'll look at what I mean by digital services, and then what insolvency risks are presented, and how under current insolvency laws those cases would be handled. I'll add to some reasons why it's important to pay attention to this sector. And the key point is because things have changed. COVID-19 accelerated changes that might have happened anyway, because already there was greater reliance on digital services, as I say, to access software, to have faster internet transactions and easier ways of transacting over the internet. And as an illustration of that, people working at home. In April, so the height of the lockdown, 46.6% of people did some work at home, and 86% of those did so as a result of the pandemic. You'll all be aware that there have been significant changes and people still work at home a lot of the time. I used to go into the office every day, but because it's 26 miles away, it's easier for me to work at home and go into the office when I need to teach a class. So it's the internet and technologies like it that enable me to do that. And if, for example, internet connection goes down, we know the difficulties that that presents. We can't access things like Teams. We can't access other software that we might depend on. So I'm here showing my...
One second.
Yeah. Is that the next one? Yeah. If we look at how digital services are dealt with in insolvency legislation at present, they are there. And that is in section 233, which deals with essential supplies. So if a debtor gets into difficulties, they are guaranteed continued supply of digital services because those are important to many businesses now, and denial of digital services could kick the legs out from a company that was struggling. So the importance of this sector is therefore emphasised, but there's no equivalent protection for customers if it's the digital service provider that's insolvent. So there's a risk of essential services no longer being available and to a wide range of persons. The importance of digital services is also emphasised by their inclusion in the Network and Information Systems Regulations 2018. Quite an obscure title, but a very important system of regulation because it underpins resilience in essential services that we use every day, things like utilities and transport providers, and included among those very high-level vital parts of the national infrastructure are digital services. So their inclusion in that list puts them among sectors which need a high common level of security and which are subject to risk management and reporting requirements. So this goes back to what I was saying earlier about how a lot goes into risk minimisation, monitoring of potential problems. And so there are safeguards, but nonetheless, digital services companies can get into difficulties and can fail. And the illustration is a data centre operator, 2E2. So that's what an example of what a data operating centre looks like. And if your data's in the cloud, it will be somewhere in there. Not specifically that data centre, but one like it. So data centre operator failed and went to the customers to ask for money to keep operating. And it needed almost £1 million to keep going. It was estimated that it needed 16 weeks to do that. The reason why it takes a long time is because these businesses are complex, they may not have many staff, so there's a steep learning curve for any insolvency practitioner who goes into one of these firms. And also extracting, this was a data store, extracting data that's stored off-site can take a long time. It takes a long time to upload data. If you move on to Amazon Web Services, they will send a truck, if you've got a big enough account, that, you know, rather than one of these little data sticks that everybody's familiar with, to transport high volume of data, they will send you a truck called Snowball. And it's that size of task that would have to be done in reverse. And if they were going to get into difficulties, you could be sure they probably won't be sending a truck. So what are digital services? Probably lots of things that we're not familiar with. So included in the essential services in the 2018 regulations discussed earlier are things like top-level domain name registries and domain name services. These are aspects of how internet traffic is dealt with. So if you want to visit a website, rather than having to type in a load of numbers to access the right website, you will have a nice www address that would have been allocated by a top-level domain name registry. And look upon those as being equivalent to title registries. It shows who owns valuable property, because internet names, website names, as we know, can be very, very valuable. Domain name services is similar to the telephone directory, that it enables traffic that's directed at a particular address to reach the correct place. Internet exchange points are part of how internet traffic works. So rather than it magically, if you send an email, rather than it magically going into somebody else's inbox, it will pass through various points that are there to make the transmission more smooth. So if any of these things, if any of the companies providing these services was to get into difficulties and shut down suddenly, that really would break the internet. It's an overused phrase for various things, but this really would be an example of that. So these are treated as essential, and these are among the ones where there are lots of safeguards, but where there would be big problems if those safeguards failed. Also included in digital services, I mentioned earlier cloud computing, because that's the one that I've paid most attention to. But also things like online marketplaces and search engines that we use every day. Well, not online marketplaces necessarily, but search engines. So these services are very important to us. But if they become insolvent, we've got an underlying tension that we as customers need to recover our data. If we're relying on services, we need to find alternatives. So if we're accessing software, then we need to find alternatives. And it's going to take time to do that. So I should mention that I'm looking here at the situation if one of these digital service companies gets into difficulties and is no longer viable. Obviously, if there is underlying viability, then there are the rescue procedures that have been discussed. But what if it was in serious difficulties and couldn't continue? To what extent is it possible to have a managed close down so that customers can recover their property, which is their data, and can continue to access services, including software that they need for even the readability of their data. There is an underlying tension. The insolvency procedures largely are there to protect creditors so that they don't lose more money. And rightly so, because it's their money that's at stake. So insolvency procedures aren't really set up to enable continued trading by businesses which are no longer viable. The possibility of insolvency has been mentioned in some computer science and other technical literature. So the computing side is aware of this, but they just tend to say, "Oh, that would be bad. That would be difficult to resolve," and it really needs knowledge of both areas to try and work out what's to happen. The article that this paper builds on is one that I wrote with a computer scientist. From him, I had awareness of what real potential there is for a case of difficulty. But it does need some collaboration between the insolvency field and people with knowledge of the technicalities, because it can be quite a complex industry with different companies performing different functions in online transactions. And it's part of that structuring, that layering of different services that makes it difficult to resolve these cases. Looking at the insolvency procedures, so this is going back to the point that insolvency procedures really are geared up to protect creditors, not to protect employees. And therefore, there isn't really scope for this sort of managed close down in the interests of customers. Administration obviously can facilitate ongoing trading, but the administrator is to carry out the objectives of administration in the interests of creditors as a whole, and therefore not in the interests of customers. Ongoing trading in the interests of customers generates more costs that further deplete the sums owed to creditors. Liquidation is not designed for temporary ongoing trading. The new moratorium is only available if there are prospects of saving the company. So again, that's not really to have a managed close down of a company that is failing and on which customers are dependent. I put these digital service cases among a category of cases of potentially wide public impact. And I looked at other industries that are of this type. So banking, peer-to-peer crowdfunding, and also the airlines. And what we see in these is a combination of ex-ante safeguards and ex-post approaches for what if the worst happens and one of these businesses will fail. So in banking, obviously, you've got a very complex regulatory system with controls on entry and things like customer deposit safeguards, and also specialist tools available in the event that any of them becomes insolvent. The crowdfunding industry has entry conditions. Financial Conduct Authority authorization is required. So again, there's failure prevention, and these firms are required to have wind down arrangements. Digital service firms are not. We saw with the airlines an example of an industry which has similarities with the digital service industry. Looking at ex-ante regulation is highly regulated, barriers to entry and rigorous regulation as to safety standards, etc., and licensing. Ex post, there was a proposal to have a special insolvency procedure for airlines, but as it stands, we've got this ad hoc approach where there were state institutions step in to repatriate customers, which we saw impressively done in cases like Monarch and Thomas Cook. A running theme in much of this is protecting the functions that the entity provides, rather than providing bailout to enable the entity itself to keep going, which is a point that Eva Hookers has made in relation to banking. Desirable to protect the functions in the interest of public protection, but not the entity, because that would give rise to issues of moral hazard. As mentioned a couple of times, there are lots of ex-ante safeguards for digital services. The 2018 regulations that I discussed previously, and you've got a broad regulatory structure involving best practice organisations. ISO's looked at it, and there are lots of other examples of good standards, but maybe more can be done with specifically mind to insolvencies. Going back to those 2018 regulations, if you look through the sorts of enterprises that it applies to, most of them do have some sort of special insolvency procedure. And the example of that, which we're all familiar with recently, is suppliers of gas and electricity. Many of those have failed, but customers, including myself, have felt no impact of that, because there's a good system to transfer onto the supplier of last resort and then onto some other supplier that's more healthy. But that's a model that works for that industry. There might be a different way in which digital services could be handled. I should mention also the position of customers, because to some extent we'd expect customers to look after themselves, exercising due diligence in choosing digital services and structuring them so that there's no single point of failure that would really lead to difficulties for their business. And then other things like cybersecurity and risk diversification, and there may be some contractual approaches that you could take that would protect the customer. I mentioned that one already, so lots of specialist insolvency procedures. And then briefly, another possibility is the approach in Luxembourg that gives customers a right to recover their data if there is some sort of a problem with a service provider. That addresses one problem, but it doesn't really address others, such as how you fund insolvency proceedings in this context. And really, that was done with a view to making Luxembourg a good destination for digital services. And there's an advantage to be gained, I think, by any country that really gets its act in order in this context. Okay, so it went on a bit longer than I'd intended, but thank you.
Thanks very much, Rebecca, for that very interesting paper, with some nice synergies with Inga West's paper earlier on public interest and insolvency as well. So just whilst I wait for, hopefully the cloud server hasn't gone down for the questions, or we'll get ironic. Snowball, yeah. Will have to come along. But yeah. We'll wait for those to kick in. But in the interim, are there any questions in the room? Yes, we'll go to you first in the front row.
Hi, thank you, Rebecca, for your presentation. It's quite interesting. I have, I guess, a two-part question. The first one, have we or are we reaching a stage where certain digital providers essentially become too big to fail? And if so, especially in markets or sectors where there are no natural replacements for a company, is the practical solution that we will see more of government bailouts and stuff along the same lines where we simply cannot let a provider fail?
Yeah, too big to fail is definitely a risk that has been appreciated. It was highlighted by Lloyd's of London, for example, and there are household names that we would know that are in that category that might not think that they would fail, but we don't know all of the businesses that really could have that impact. Some of the ones that determine internet names, for example, because so much depends on that, could be examples. I think preferably government bailouts would be to be avoided, and it'd be better to look for some way to protect the functions. But we saw with the banks that that's not always possible. So it could be that sort of scale that we're dealing with for some of these companies.
Thanks very much. Any more room-based questions? We're still waiting for, I fear that the cloud has gone down because we don't have any online questions. So yeah, there's this one here.
Hello. I wonder if we ought to have some kind of like ABTA protection scheme for this particular industry, like we have in the travel industry. Is that something that so it could self-fund any issues?
Yeah, that was something that in the cloud computing paper that I did, I considered whether there was some sort of a levy that could be imposed, bearing in mind things like volume of business traffic. It might be difficult to impose on a lot of these businesses are supranational, so they can evade it in the same way they can evade taxes, maybe.
Just at the back over there.
Thanks. Hi, Rebecca. That was really interesting, actually. I think one of the things is in terms of when we think about, the banks, it's kind of obvious who the banks are who take over, and they're UK based, and we know that we've had sort of pretty good regulation all the way through. And, when we look back to the really big crisis, it was 2008, and the world looked a very different place then than what it does now, because I think digital's just moved on exponentially. So that's a really big issue, isn't it? Our international, the fact that this is all cross-border, the fact that we've got people who have got, where does your business exist? Where is your server? Is it actually even in a jurisdiction that you actually know about? We don't know where the cloud is for any of our stuff. So how do we deal with that? Because we never get really any kind of international agreement on these big issues. So where do we go from here?
Yeah, I mean, ideally that would be the direction that things would move into, that it would be dealt with on a global level, but there are great difficulties with that, as we saw, even agreeing a minimum level of tax, which can be undermined in all sorts of other ways. But the banking is a good one to pick up on, because it is that type of risk, and also that element of being caught out by things that we don't properly understand.
Is there anybody obvious who's like our, if you think about the big four, maybe the ones you'd look to sort of carry, customers from who had to transfer their business? Are there any, who are the people we'd look at as being the big players here? Is it possible to identify them?
It might be that the big tech giants that we know about could develop acquisition skills. This digital services industry does have quite a lot of responses to problems by the industry itself, because obviously they want things to work well, and so in the past they've solved problems about faults in code, etc. So it may be that the industry would come together, but a lot of these are providing quite different services, and it can be quite difficult to understand all the nuances of that right away, even for specialists.
Yes, that's quite interesting. They're entrepreneurial by nature, aren't they, these people? So therefore they should be able to work out their own solutions.
Yes, some of them are.
Just a follow-up question here at the front, and whilst that's being asked, are we sure that this is feeding through? Any questions that, have you got any?
Breakout room?
Yeah, that's,
Is it not working?
no. Oh, right, excellent, good. There's one, oh, here we go, excellent. Yeah, well, so we'll take this question, then we'll come to this one.
Yeah.
So yeah, I just had a follow-up or a clarification of sorts.
Yeah.
When it comes to digital providers, are you or do you believe we should, especially for those companies that deal in personal data of consumers and customers, are we looking to prioritize their interests rather than the creditors who perhaps could be agreements with other digital providers in terms of advertisement and marketing? So is it more about protecting the customers and the clients who have personal data on those web servers per se, or something along those lines?
Well, that's the fundamental question and the tension which is at the heart of these, and it is a matter of national decision making in that regard, I think. But I would argue that because society now is so dependent on digital services, there needs to be thought given to customers, because there would be very real impacts.
Yeah, that's as opposed to what goes on with every other industry where customers are essentially unsecured creditors. Okay, awesome. Thank you so much.
Thanks very much. So, right, we'll go to the online question, and if there are no others, I might ask you one or two. Yeah, so the online question comes in from Kazi, which is there any consideration of the rehabilitation plan included in the scheme?
Yeah, I specifically wasn't looking at companies that were viable, that would be suitable for rehabilitation. It goes back to the point about if entities aren't viable, we shouldn't really be trying to rescue them unless there's very good reason, because that undermines the healthy functioning of markets and also leads to moral hazard problems. But certainly if digital service companies had underlying viability, then there's a good range of tools that can be used. So that wasn't really the point that I was looking at.
Thanks very much. More of a wind down
Yeah.
process. Yeah. Thanks very much. So the next online question we've got is from Anonymous, which is, so what should Plan B be in each country if international agreement action isn't possible to prevent the risks of large digital service provider insolvency?
Yeah, I mean, that is Plan A at the moment. That each country it needs to look at this itself. Preferably, there would be a global approach, but those models that I looked at earlier, the banking one, the crowdfunding one, and the airlines one, offer different possibilities. The things like the utility services, that provides another model where you've got a special insolvency procedure. It's, as I say, it's something that states individually need to think about in the context of how these services operate locally.
Thanks very much. Okay, any more in the room? If not, okay, I'll ask my one. Well, a couple. So the first was, I was wondering if your computer scientist friend and co-author had suggested to what extent this might actually be a problem. So does government need to be nervous that there are going to be lots of snowballs going about the place, or?
It's interesting, because the guy that I wrote it with was my student a few years ago, and wrote his dissertation on it, and then I didn't think about it for a couple of years, and I sent him a message saying, is this still a problem? And he said, oh yes, it's got worse. So it's sort of a problem that is, there's a very real risk, but it's sort of snoozing at the moment.
Yeah. And the other question, if there are no others in the room, or I'll go to Robert and then might have time left. So Robert at the front.
Thank you, Rebecca, for your presentation. I have perhaps an interesting related question. It's the extent to which businesses regard this as a risk, and given that we require businesses to disclose through financial reporting principal risks, I wonder to what extent this is seen through reporting obligations as a risk.
It could be. Preferably, businesses would think about how to structure the services that they use. For the cloud, for example, there's growing usage of these are called the multi-cloud. So I think some companies like that could use it as a sort of selling point if they've got good setup. If they've not got a good setup, they might well not know about it. One of the problems that we had in 2020 was because of the volume of stuff now being done online that previously wouldn't have been. There was a massive learning curve for data people, and there were problems, but I suppose they don't know what the problems are until they happen. All they can do is sort of things like diversification of risk. And the banking sector is very concerned at the moment about how much, there's a lot of banking that's done in the cloud, and risk presented by that banking regulators are quite concerned about. So yes, companies generally should be concerned about it too, and it's not a point I'd thought about, but it's a good point about reporting.
We've got another question just, with Inga, and then just behind you, I think. Yeah, thanks very much.
Really just an observation about the sort of the flip side of it, because it used to be if you went into a company and to sort out its insolvency, you would go to its systems and you would pull off its finances. And now you go into a company and its finances are sitting on 200 or so platforms, all of which are on a serviceable contract, which you have to keep paying in order to be able to access the information. So it's really, I mean, to pick up on Robert's point, it's a massive point, if, not just in ordinary trading business, but also particularly on insolvency.
Yeah, it's not a dimension I'd thought of, but of course that's quite right.
Okay, I think, was it Katerina?
Katerina.
Oh, no, okay. Did you? No, okay. Sorry. It's like a residue hand on Zoom that I thought was there, but
legacy
hand. That's it. Yeah. Sorry, trust. But yeah. So, Mike, if there are no other questions, I've got one which is basically, this might make Dean nervous. So, I was thinking when you mentioned the domain names and registries, and I was thinking about ultimately the idea that the state indemnifies any issues with the land registry, and then similarly with Inga West's paper earlier when she mulled on the pros and cons of public interest insolvencies and where disclaimer sits, and the idea that ultimately when freeholds are disclaimed they issue to the Crown, so the Crown's then got another problem anyway. Do you think ultimately going forward, where these types of services that we're thinking about are so critical, I hope we know MI5, MI6 and GCHQ now keep their stuff in the cloud as well, that ultimately the government at some point might have to either address this, not because it's some sort of special case pleading like a sector-specific pleading, but just that it's so fundamental to what we do that we cannot enable this kind of lack of service to happen. So in other words, will the government at some point have to, because they'll be pushed to interject if they don't?
Yeah, but perhaps, and if it was a case such as that, the equivalent would be the likes of Monarch and Thomas Cook, where the state picks up the obligation to customers to tidy up the mess.
Yeah, yeah.
So is that what happens in Luxembourg? Because you mentioned about they can still access.
That section is to protect the customer's property. The contract ought to do that anyway, and there's not any wider development of it as far as I know. So it doesn't deal with things like who pays for that.
Okay, I think we've got probably our last question because of the break and our need to get back to the plenary session, which might have been inspired by that mention of MI5, MI6 just now, because it's this. Current concerns seem to relate more to hacking and hostile state penetration. Hackers surely have an interest in keeping the internet services going.
Yeah, I'm tempted to say Mr. Bond, I've been expecting you. hacking is one of the risks. Who knows what the incentives are? There are all sorts of directions that hacking can come from, and they don't necessarily all think in the same ways.
Okay. Thanks very much. On that point then, I think we'll wrap up. So if we could just give Rebecca another round of applause. Thanks very much.